Welcome back. Again, my name is Eric Prosser. I am the Engineering and Entrepreneurship Librarian and the Interim STEM Division Head at Arizona State University Library. And I'd like to welcome you to our local resource panel. And for all of you who have been here with us throughout the day, this is the last session. Thank you for sticking with us. And for those of you who may just be joining for this session, let me just kind of go over a few of the housekeeping notes that we have. First, we are meeting in Zoom webinar format. So all the attendees have had their audio and video disabled, but we still welcome your questions. So please use the Q&A option at the bottom of the Zoom screen to enter questions at any time during the presentation. If you'd like to put your questions in the chat, please begin them with a Q or the word question so our moderator can easily find them. If you'd like to view live closed captioning, please click the CC button on the bottom panel of your screen and at the bottom of your Zoom screen. And then, sorry, excuse me, please click the CC button on the bottom panel of your screen and choose Select Live Captioning. And then finally, I just want to emphasize that none of the advice and answers today are intended as, nor should be construed as legal advice. Any questions for which a legal opinion is required, you should refer to your own counsel. And so with that behind us, I am pleased and happy to welcome our panelists today, Lou Farina, Peter Grant, and Catherine Costella. Let me tell you a little bit about them before they talk about themselves. First, Lou is a small business analyst at the Maricopa SBDC, specializing in technology commercialization. He is a former technology executive with Fortune 50 corporate ventures background, and had been involved in many new ventures, mergers, acquisitions, turnarounds, and divestitures. He has led large-scale corporate investments involving hundreds of millions of dollars in capital and revenue on a global scale. Lou is an accredited investor and has been a member of Arizona Angel Groups. Locally, he's worked as a strategy consultant while also serving on many advisory boards. He's been an NSF I-Corps National Mentor and has also served as an official SBIR reviewer for the National Science Foundation. Lou completed his Bachelor's of Science in Chemical Engineering and MBA from the State University of New York at Buffalo. Peter Grant has been a board member of the Inventors Association since 2017 and an active member since 2013. He has a strong background in federal patent and trademark information and market research, and has been instrumental in helping members get started with and move their inventions to the next level. And then finally, Catherine Costella is a rising third-year law student in the Lisa Foundation Patent Clinic. She attended Emory University and earned a BS in neuroscience and behavioral biology with a minor in African studies. Prior to entering law school, Catherine was a 7th through 12th grade math and science teacher at a local charter school here in Phoenix, Arizona. At the Sandra Day O'Connor College of Law at ASU, Catherine's particular interest is intellectual property with an emphasis on trademark law. In addition to working toward obtaining a law, science, and technology certificate, she is a research assistant for Professor Trevor Reed. Her research focuses on the intersection between intellectual property and federal Indian law and works to help Indigenous creators and entrepreneurs to protect their intellectual property. Catherine's many honors and awards include being recognized as a 2020-21 Sidney B. Williams Jr. Scholar by the Foundation for Advancement of Diversity in IP Law and a Diverse Attorney Pipeline Program Scholar. After graduation this spring, Catherine will be joining Louis Roca, a local Phoenix firm, as a business transaction and real estate associate. So thank you all for joining us today. And the first thing I'd just like you all to do is, if you could just tell us a little bit more about yourselves and about your programs and how they can help our attendees. Lou, you're top left on my screen, so I'm going to have you go first.
Okay, well, thank you, Eric, and hello, everybody. It's nice to be here and join you this afternoon. Again, Lou Farina from the SBDC, and most of you are asking yourselves right now, what is the SBDC? And so I'm going to tell you, it's a small business development center. It's a national program and it provides no fee business advisors for small businesses. We're partially funded by the SBA at the federal government. In the state, we're funded by the Maricopa Community College District. All that means to our clients is really there's no fee. Your fee is prepaid by the tax dollars. We've got a cadre of business analysts, business advisors here in Maricopa County that serve the county. Being a national program, there are organizations in each state. In Arizona, we've got 10 different geographical centers. So there's a center in Flagstaff, in Yuma, in Prescott, and Show Low. So there's resources everywhere. We concentrate a lot on Main Street businesses. So the small businesses, the tire shop, the restaurant, nail salon, etc. But we do have a specialty in technology, and that's what I've been heading up here for the last couple of years. And so my emphasis is on technology-based businesses. I do a lot in the community with technology-based startups, early stage, and of course we have the intersection of intellectual property in that area. So again, we're a no fee service. We take anybody who needs the help or the assistance and wants to work, and we're glad to be here.
Thanks, Lou. Peter, can you tell us about your program?
Alrighty, so I am a board member of the Inventors Association of America, a nonprofit organization founded in the mid-1990s by a young inventor and entrepreneur named Lisa Lloyd, who invented a product, brought it to market, and realized that there was no help and support for her through that process. So she started in earnest the Inventors Association. She moved on for a little while, but the organization itself has sustained itself to the present day. She recently has rejoined us and is now our executive director once again. But we are a completely nonprofit organization with an all-volunteer board, and we are here to help inventors who are independent at all levels with any level of the invention process. We meet twice a month. Our first meeting is an open meeting where we have a keynote speaker, usually an expert or somebody related to some aspect of inventing. It can be a marketing expert, it can be a machinist, a 3D printer, a patent attorney, you name it. And then our second meeting of the month is our closed meeting. That is members only, where everybody is under a non-disclosure agreement. And that's where the real magic and the real help happens. Because you can come to us to one of those meetings and you can present anything from an idea that you have on a napkin to an already patented developed process that maybe you're working on prototyping, or maybe you are in touch with somebody who wants to license your invention and you have a couple of questions about that point in the process. We can help you. So it is very much a think tank style organization.
Great, thank you. And Catherine, can you tell us about the clinic at ASU?
Yes. Hello, everyone. So the clinic is one of many clinics offered at ASU. Obviously, today is focused on the Patent Clinic, which primarily works on trademark registration and patent registration. So we offer, again, no fees. It's mostly student run with the overseeing director, Michelle Gross, who's a IP attorney in the local area, Phoenix. And again, we do anything from doing provisional patents to patents, and then trademark registration from the opinion search to getting that certificate of registration. You can apply through the USPTO website. You could also apply under ASU. And we are just one of many clinics. There's a lot of clinics offered at ASU, ranging from business innovation to immigration. And this clinic has been running on, I believe, funded locally through the Lisa Foundation and donated founder of the patent attorney. And so, yeah, I'll continue to talk more about the clinic, and I look forward to discussing. Thank you.
Fantastic. Thank you all so much. Let me throw out just kind of a big kind of broad question first, that just to get your thoughts on it. But We've had a lot of instruction today from the fantastic folks at the USPTO about, patents, trademarks, the background of intellectual property. But why are patents and trademarks so important for entrepreneurs? And at what point in the entrepreneurial process should they really be thinking about that type of intellectual property protection?
I would say as soon as possible, because as you start your business, you will have intellectual property, whether it's a trade secret, a copyright, a trademark, or a patent. The sooner you start thinking about it, the better, especially when it comes to your trade name, because oftentimes new entrepreneurs get really invested. I'm going to start a business. Hey, I'm going to call it this. And then they start taking a couple of steps and they go, oh, somebody else is using that trademark, or oh, I might run into trouble registering it. So as soon as possible, familiarize yourself with the basics of intellectual property.
I would say for sure to start to think about it. It's important. I mean, your effort and your what you're thinking about is going to create intellectual property, whether you document it or not. So you have to be aware that just going through the process, a lot of times you're creating intellectual property. But I always caution my clients to, about investing resources in it too early, right? So if you're creating intellectual property for the sake of starting a business, let's say, and that's not always the case for everybody, depending on the organization. But if you're an entrepreneur, you have limited funds and capital is really scarce. So you got to be really careful about when you actually start that investment process, when you start that clock ticking. There's a lot you can do before you invest the resources and the time. And you should do it before again, you invest the majority of your capital.
And then I'll add on to that. I think it kind of differs a little bit on the trademark side. Again, our legal regimen is first to file. So you definitely want to be thinking initially when you're making that initial investment into it. But trademark, we don't really have that disclosure element to it. We want, your brand name to be out there. So again, you do want to be thinking that initially before you start investing that money, but you have some common law rights to your trademark. Again, it will limit you to a geographic scope. So in terms of like whether you are thinking you are going to be, cross country or whether you're going to be just a local company, that also influences whether you even want that constructive use of the trademark. But again, that's something that is oriented to your personal business goals and client goals.
Great, thanks. And Catherine, let me follow up with you a little bit. And this is on something that Peter mentioned too, because Peter mentioned, having a trade name. And there have been some questions today in some earlier sessions about the difference between a federal trademark versus a trade name, such as a fictitious business name or a DBA. What are some key differences between the two? And what are some steps to say protect a trade name versus a trademark in Arizona?
So trade name is, what your business is known as, additional things. So some clients come in with like having certain like name, but then obviously go by to clients by another name. So usually trade name is protected at a state level. So you register that with like the Arizona state, and I think it's like a $45 certificate that gives you that like trade name that you're using. But again, that's only like state protected and will only filter out to who's using that name in your state. That generally is like helpful when it comes to like trademark registration in terms of like whether it's like litigation that you could prove like, hey, I was using this name a little bit like earlier, like this person filed saying, they used this name in 2022, but hey, I already was using that as a trade name. So that kind of is like a little bit of evidence towards litigation. But again, most of our clients don't have the means and funds to be litigating. So you generally want to be searching also whether your trade name is trademark registrable. And then trademark registration is a federal constructive use of your name and your brand. So that again is going to go through the USPTO and it's not at the state level. And so I think that was all your questions. So those are the difference. It's state level protection versus federal protection. And, usually the better one is federal protection. That would give you the constructive use across all states.
Great, fantastic. Lou, Peter, did you have anything to add to that?
I would agree with everything that's been said. And keep in mind too, that many of the things you learned in earlier sessions today, you can either do yourself or you can do for free. So again, look at what can I do for free? You can do your own basic trademarkability search, look at what's out there for effectively free. You can also look into patent resources if that's something that you're considering. There are steps you can take, again, that cost you nothing out of pocket. But also when it comes to making those heavier investments, as was mentioned, also be sure that you've done your market research, for example, before you go ahead and pursue something, especially like a patent, which is more expensive than a trademark. You can always see, is there a market for this before I get a patent on it?
Awesome. So what are some steps? What are the next steps, let's say, for a business after they actually receive? Let's start with a trademark, because we'll treat patents and trademarks separately, because I think there's going to be some different advice here. But once a business receives a trademark, what are some of the next steps, the immediate steps they should do at that point?
I guess, changing, most clients are already using like the TM symbol, which means it's not a registered trademark. So, and then some are using SM, service mark. So most of the clients will have that on like their websites or business cards. So once you get it registered, now you can start using that R symbol. So you can update your websites to feature that, to make sure that you're showing people, hey, I'm registered now. I have, the right to this. And also, like, oftentimes, if you're not right now using the TM symbol or the SM symbol, I would encourage you to use that, because that oftentimes deters people from even like trying to seek to use your name or like, steal your trademark name. Because oftentimes general consumers don't understand the difference between TM, SM, R, unless you're like a little bit more sophisticated and you actually are registering your mark. So in general, I would say use your marks and then use them correctly once it's registered. Second, you want to make sure if you're working with like an attorney or the clinic, you want to make sure you are the primary correspondence to the USPTO. So that way, when it comes to renewals, a lot of people don't realize it, but you have to renew your trademarks. And that comes in the 5th year and the 6th year, and again in the 10th year after registration. So once it's registered, a lot of stuff could happen, your attorney could retire or whatever. And like, if you're working with the clinic, termination of the of representation terminates like any communication. So like 5 years, obviously I'll have graduated students are, turning over. So our first step would be making you the primary correspondent. So you have direct communication with the USPTO, and that you're just familiar with that USPTO system. You have an account, so that way you can check your own registration, see if there's any updates to it, check filing fees and all that. So those are my 2 recommendations.
Awesome. And then I guess the second question is, following up on that, what should a business do once they receive a patent? And, Lou, this might kind of go towards you with your background in venture capital and finance. Once the business has a patent, does that make them more attractive, say, to investors at that point?
Yeah, you really, by the time you're talking to investors, you should have filed something, right? Whether it's a provisional or you've received your patent, because it becomes an asset on your books, and it shows differentiation, as well as protection. So, but I will tell you that, while it's important to have that protection as you're talking to investors, just because you have the protection doesn't mean the investors are going to invest, right? So they look at it as a necessary step, but of course, the idea and the team, the business plan, your current market traction, all will really determine whether it's investable at that point. It's important also though, just to point out, not to file that provision, maybe provisional too early, and Peter can probably comment on this, right? So you get the clock ticking. A lot of folks think they have to file that provisional right away, and you got that year, and sometimes things take longer than you really thought they would. So you're kind of running out of time.
So that is very true. And it comes down to doing some of that market research, coming up with a bit more of a business plan before you decide to file for your patent application. If you do file a provisional application, that does give you 1 year to follow up and file a non-provisional utility patent application. Sometimes if you file too soon when it comes to a provisional, what can happen is you don't have enough information in your provisional and you don't benefit from that early filing date. The other risk is that you don't have enough time to get your invention or your product where you need to go. And in many cases with independent inventors, I know the question was asked, what should your business do? If an independent inventor is awarded a patent, they may very well be at the point where they need to form a business entity to take ownership of their patent. And then from there decide, is this something I want to try and bring to production or manufacture myself? Is this something I'm already capable of manufacturing because I own a business? Or is this something I would like to license? And many people believe that licensing is an easier path, and in many ways it is. But when you license, you are still forming a business. You will still need a marketing plan, a sell sheet. You will have to negotiate a licensing agreement. You will have to find a licensor. Initially, it is very similar to the process of setting up any other business.
So Peter, let's expand on that a little bit. If it is an inventor who wants to license, how do they go about finding, someone who's interested in that license and has the capability to manufacture at that point? Is that something that your organization can help with?
Yes. One of the ways you can do that is through market research of your own. Databases such as Data Axle can be searched by NAICS or SIC codes, which can help find you manufacturers in certain industries. Sometimes inventors know the industry that they're in well enough that they have some existing connections. There are some invention assistance or accelerator firms that actively connect inventions with manufacturers that produce. But our organization is one where we have members that have invented in many fields. And oftentimes there is somebody who knows somebody, or even some of our presenters are folks that operate invention sourcing firms. So we can, in our closed meeting, discuss that with people and connect you with reputable firms or firms that our people have used in the past.
So I'd like to add also that I agree 100%. The licensing side, for a lot of entrepreneurs are fairly naive when it comes down to the licensing side, because they think that if I've got a patent, somebody, I've been awarded a patent by the USPTO, it's got to be valuable, and therefore people are going to find me. And it's the complete opposite. It's really, really difficult to do. Peter's shaking his head. I mean, you guys can assist, we can make connections, but it's a lot of legwork, and it's a lot of no's, and it's a lot of, it's much harder than folks realize. So I always caution my clients, reputable firms, Peter. I mean, it's terrific because there's a lot of non-reputable firms out there that can take advantage of inventors because they are kind of naive. So yeah, I'd love to get those connections at some point.
Catherine, does the clinic assist with licensing, or do you focus mainly on the patent prosecution side?
We offer some limited, I believe we offer like the templates to obtain like licensing agreements and non-disclosure agreements, like employee-employer agreements. So we offered limited support in that, so that way the clients themselves can go seek those. But yeah, our representation is usually limited to just the registration aspect. Yeah, unfortunately, because we're not licensed, we're only limited practitioners. It's student run, so yeah, we're limited in that way.
Awesome. So Lou, I heard you mention disreputable firms there in one of your replies. I know I learn really well from mistakes, and even better, sometimes I learn from other people's mistakes. Do you have any, kind of common mistakes that you've seen businesses make with respect to patents and trademarks that we might be able to learn from here?
Well, again, I think the biggest mistake, and we've said this a couple of times, I'll emphasize it, is just not making the investment in time on the front end before you really dive in with the intellectual property. That's the biggest void. And we call it, it's called a lot of different things, but we call it customer discovery, right? It's that discovery. It's finding potential partners or customers to help you validate your assumption on whether this is actually marketable or not, if you can actually make a business out of it. And then the other mistake is thinking that a lot of the an individual inventor can create a business on their own, and a lot of times they can't. It takes a team of multi-skilled people to do that. You can form a team of co-founders with some complementary skills. Another way to do it is go out and find what I would call an informal board of advisors, people who are willing to help you. You'd be surprised how many people, I'm sure, Peter, sounds like you work with a volunteer group, who are willing to step up, and if they know you've got a need, they'll give you some good advice without taking anything monetarily or stake in the business. So going it alone, I think, is a real pitfall.
I agree completely. Somebody many years ago told me that you cannot be the CEO and get coffee. So anybody, especially embarking on starting a business or especially bringing an invention to market, you have to take a serious look at what are my skills, what can I do myself, and what do I need to hire somebody for. So for example, while you've been taught how to do a preliminary patentability search, you might have looked at that and thought, there's no way. I already need an Advil. I can't do this. So perhaps your resources are better spent either pursuing resources that offer free assistance, such as a patent law clinic, or hiring somebody to handle that aspect for you while you work on aspects of the business that come to you more easily or are more suited to your skill set. And yes, our closed meetings could very much be likened to kind of your own personal board of directors or your own market research. Oftentimes when we have our members present their product, number one, it is under a non-disclosure agreement. So it does not start the public disclosure on your patentability. But number two, that is where you can show people and they can say, we would not buy this, we would buy that. That's a great idea, but can you sell it for a retail price that could match or compete with an existing product? That's very much where that think tank aspect of our organization occurs.
And I'm gonna hijack that a little bit, because you mentioned research being important, and I feel like as a librarian, I have to emphasize the skills that librarians have as researchers. And so not only librarians, say at ASU or at U of A or NAU, if you're near one of the big universities, but also public librarians. Many public libraries have business centers, and the librarians there have the training, and the librarians at the state library with the Patent and Trademark Resource Center. But yeah, definitely use librarians. We love doing research. It's what we are experts at, and usually we're free. So it's a nice price for that. We did have a question come in from one of our attendees, and I just want to throw that out there right now. Is there a good place to go to find board members and or partners? Where can they go for that, to find that kind of support?
I would say you got to go to where the action is. So a lot of times it's just on the ground networking, and there's a lot of pitch events that tend to attract different types of people with different skill sets. I know ASU does a terrific job of pulling things together, but there are things that are outside of ASU. Phoenix is a fairly fertile area right now, and as we get back to doing things in person, it becomes a whole lot easier. And so that's one of the things I advise my clients is just get out there and go to different pitch events, go to different networking events with that attract an entrepreneurial community. You never know who you're going to meet. Honestly, you don't.
Yeah, and I second that. Join trade organizations, entrepreneur organizations, basically get involved in the community. Like whatever industry you're in, there's usually a community within Phoenix or whatever city you're located, and then just start meeting people through there. And that's how most of my clients find their partners and investors. And then for that, I would caution also make sure you have NDAs. But yeah.
We've heard NDAs mentioned, I think maybe by all of you at this point. What are some features that people should be looking for if they're, looking for an NDA because they want to, start talking about what their idea is and do that in kind of a safe space and in such a way that they're not starting the clock and they're not publishing it out there? Are there handy NDAs, say, available online? Do you have to go to an attorney for that? What are some key things that should be included in any type of NDA we're looking for in this? I know that's a big, broad question there.
So, Eric, before we answer that question, I'm going to throw something out here, and this flies in the face of some rationale. But if you're out talking to investors, let's put VC aside. If you're talking to angels, angels will not sign an NDA. You will not get angels to sign an NDA. The reason being is, having been an angel, seeing so many deals come through, potential deals, we can't keep it straight. So from a legal perspective, we could never actually, adhere to that NDA per se. Now, most angels aren't there to steal ideas, honestly, but there's a tightrope you have to walk between what you can disclose, the secret sauce we call it, and what you can talk about publicly to be able to get enough interest.
Lou is exactly right. A lot of angel investors or even casual patent agents or patent attorneys that you might encounter at networking events will not sign NDAs. So if you develop an NDA, be prepared for people to refuse to sign them. But also keep in mind too that you can discuss your product without disclosing the secret sauce. So I am working on a product that does X and it solves the typical problem of Y. And then from there, once you've had that conversation, oftentimes the next step in the relationship is signing an NDA. When it comes to advisors or a board, keep in mind too as well, you can form your own sort of personal board of directors. Oftentimes you could reach out to somebody that you would like to be a mentor, and you could just say, hey, I'm forming this personal board, will you be on it? And that can be a way to start and build that relationship as well.
Can you quickly, we had another question come in. Can you give us what's the difference between venture capital versus an angel investor?
You want me to take this one? Yeah. Okay. Yeah. So deal size and focus, really. Venture capitalists do much larger deals. and they are more narrowly focused on a certain area, a certain vertical per se. They have expertise in certain businesses. And when I say, you've talked to a venture capitalist, they'll say, we do 30% of our deals are early deals. An early deal to a venture capitalist is somebody who's been in business 2 years already making money, and they've got traction, and they need the minimum $5 million, let's say, a minimum. And they go down to 2, 5 is usually the bottom. Usually it goes on up from there. It's really, 20 or $30 million what you're looking for. Angel investors are much more local. They are formed from the community, so they have a very broad background collectively, and they do much smaller deals, and they will invest before venture capitalists. Most venture capitalists won't invest unless they see a local angel group in many times. And so there are deal sizes, anywhere from $100,000 to $500,000, $600,000, $700,000 at the local level. And again, across a very broad spectrum of industries.
Can I try to throw that into an analogy using Shark Tank, the television show?
Okay.
That the idea is that an angel investor might be involved with these ventures prior to their getting onto the show on Shark Tank, but at Shark Tank, they're really looking for the VC at that point from the sharks. Well,
the sharks, a lot of times, I mean, the deal sizes are not really VC deal sizes, right?
Okay.
If you just think about $500,000 here, $1 million here, that's kind of angel.
Okay.
Those guys just happen to have, I would call those guys, we call super angels.
Super angels. There
super angels. Yeah.
Archangels.
I mean, term. Yeah.
Okay. Excellent. Again, anyone attending, feel free to drop any questions into the chat or into the Q&A feature there at the bottom, just at any time. I think one more kind of big question out there we've touched on a lot of this, but I want to get into, they talked about defending patents and defending trademarks. And this might be a good one to start with you, Catherine, is what are some of the needs and things that go into the decision on, well, when should I be out there defending my trademark, or when should I be out there defending my patent against potential infringement?
I mean, usually when we have it registered, the easiest thing you can do is send a cease and desist letter. Usually that deters people and will shut down other people from using your mark, but sometimes, it doesn't work. And again, really just depends on your client objective. Do you have the financial means to really pursue litigation? And sometimes our clients don't necessarily have it. And plus the geographic scope, it's completely, small pop shop, in a city that's, less than 100,000 population. So sometimes our clients are not really going to enforce their trademark registrations and pursue a big, huge litigation that can cost them, thousands of dollars. But oftentimes I see a lot more success in just getting the cease and desist letters and, getting people to stop using the mark. And oftentimes when they pop up, they haven't really invested a lot of money into using our client's mark anyway. So they'll usually just go off their way and start another brand. But yeah, it really just depends on client objections, client budget, finances.
Lou, Peter, from say the investment side, is there importance put on defending marks and defending patents by the original inventors, or is that all going to be determined kind of at the time something's happening and go into say a cost benefit or risk analysis there?
Peter, you want to take this? Go ahead.
So I think it's every independent inventor's worst nightmare to confront an infringer. As was mentioned, oftentimes it is a strategic decision how you consider dealing with infringement. And that's where also thinking of your intellectual property as a suite can help you out. I know we had one keynote speaker at the Inventors Association who defended a product against infringement. And with certain infringers, they did not go after them for patent infringement. They went after them for copyright infringement because not only did that infringer violate the rights protected by their patent on the product, but they also copied aspects of the packaging. So consider too, your intellectual property suite and those kind of, I don't want to say weapons, but the options you have in terms of, somebody could very well violate your patent, your trademark, and your copyright by infringing a product, calling it something similar, and making the packaging look too much like yours. So again, it typically is most likely to happen with successful products. So by the time you have an infringer, you are hopefully also already making money. But at that point, again, unfortunately, it's a matter of being strategic. It's also, when it comes to a licensing agreement, something that you need to consider as well. If you are licensing your product and the patent is infringed, who defends the patent against any litigation? So consider that as well if you are licensing. Because nobody wants to license their patent, be getting their payments for it, and find out that they are the ones that have to pay the attorneys in the event of a patent lawsuit. So something to consider as well.
I would just add that, if you're early stage and there's litigation already, investors, it's like run away. It becomes very expensive very quickly. It can, and if you're an early stage investor, you just don't want to see your capital getting thrown into litigation, right? So we want to avoid that at all costs. Now, at some point, as Peter points out, if it's more mature and there's margin, there's cash being generated, and maybe you're at higher level, maybe at the VC level, then it becomes a risk analysis on whether it's worth it to make the investment, how much risk there is, how much capital it's going to require to defend the patent or to prosecute.
So if we're talking about, say, defending a patent, or if we as business people are being accused of infringement, I know whenever I identify a known risk, one of the first things I look at is it something I can insure against? Are you aware of, is there insurance out there that could potentially be obtained in order to protect and defend against claims of trademark, copyright, patent infringement?
I don't know. That's a good question. I don't. It's a very good question. I'm going to find out, though.
I feel like there are. That I recall that from a ways back that you potentially can get intellectual property insurance to defend yourself against claims. I don't think it necessarily pays to defend your own claims, but it might be out there. But yeah, definitely, that's something potentially to look at, is always trying to minimize that risk. Peter, I want to go back to one thing that you talked about, because you talked about thinking about your intellectual property as a suite, and I like that analogy. And you mentioned the big three, right? Copyright, trademark, patent, which the federal government is well involved in. I think there's always the fourth, and that's the trade secret too. In the Inventors Association, do you ever get into points where you're talking to people, bringing their ideas, and you might even say, that sounds better as a trade secret rather than something you should be putting out there as public knowledge through a patent application?
That has certainly happened, and that's very much a possibility. If you are confronting some IP that you believe is best managed as a trade secret, by all means, consult with an attorney for specific advice on how to protect that secret. be it through having your employees sign non-disclosure agreements or processes that you can implement at your business in order to say that you've done your due diligence to protect this as a trade secret.
Catherine, does the clinic handle trade secrets as well? Or at least, let your clients know that might be better protected as a trade secret than, say, a patent?
Yeah, oftentimes clients will come in not really generally knowing what IP is. They'll come in with like, I want to protect this, this, and that. And I'll definitely have to explain the difference between copyright, trademark, patent, and trade secrets, and kind of assess like what parts I can help register and what parts, they would have to seek outside counsel for. And then, and steps that I can give, like, I guess, a little limited advice of like, yeah, this is that, and like what you should be doing to protect that. But mostly for trade secrets and patent, non-disclosure is like key for those. Like you don't want to be disclosing those. And when you do disclose those, if it is a trade secret, you kind of lose that. But if it's a patent, then we want to get that provisional in. But yeah, it's usually just helping clients understand what types of intellectual property they're dealing with.
Eric, a lot of times I could talk about from in the corporate world, you want to keep things as a trade secret because you don't want them out there. And as Peter points out, there's protocols that you've got to go through to make sure you enforce and you protect yourself as a trade secret for your trade secrets. But on the other hand, with patents, you're disclosing, right? Everybody can see it. It's open to the world. It's out there. A lot of entrepreneurs don't really understand that, and they have to kind of rethink things once they kind of understand that. But on the corporate side, what we used to do, and we would patent things intentionally. We patent lots of things intentionally, not knowing if they were monetizable, because a lot of times we would work them and put them in the standards bodies, and then the standards bodies would pick them up. Then there were licensing agreements within the standards body. So you wanted to disclose, you wanted other people to adopt under some pre-negotiated licensing arrangements.
So Lou, you mentioned standards bodies. Can you give us a quick definition of what you meant by that?
Oh, okay. So I have background. I've done work in telecommunications, say cellular. So the cellular standards bodies, the reasons why different people's equipment can talk to other people's equipment, the reason you can use different handsets. And then on the infrastructure side, different radio vendors, is because there's a common set of standards, protocols and standards that allow people to build to enable interoperability. So that's, and there's standards bodies that manage that and publish the standards. Usually the vendors are part of those standards groups, of course, and they contribute to the intellectual property of those standards groups. And so there's licensing arrangements that are, again, pre-negotiated to allow them to recover. I mean, we've sold patent portfolios for $1 billion. Just the patent portfolio with regard to, let's say we go some of our GSM standards that can be really, really valuable.
Thanks. As an engineering librarian, I deal a lot with standards, but I was glad to have somebody else to explain that for me.
How did I do? Are you okay?
You did fantastic.
Okay.
Yeah. That was exactly what I wanted to hear. So we've got about 10 minutes left in our session. So again, I just want to invite any of the attendees, if you have questions, we're getting down to the wire. So throw them into the chat, throw them into the Q&A button there at the bottom of Zoom. Either way, I can get to them. And as we're waiting, giving some time for some questions to come in, let me just open it right back up to the three of you. And just kind of give you 1 minute here at the end to just kind of sum up and give us any important things you think we may have missed or just you want to amplify on. And Lou, let's start with you again on that, and we'll just go through the group.
Okay, well, thanks again. Thanks for letting me be here. I enjoyed this. Again, I think it's something goes back to what we said earlier in the conversation, and Peter said it, I think Catherine said it, is let's do our homework before we really dive in. That market research, that customer discovery. At the SBDC, we can help you. There's other resources that will enable you to do that. But think about putting that time in, and it does pay off in the long run.
Over to you, Peter.
Yeah, exactly what Lou said. Put your time in, do the research, learn the process, plan out a roadmap for where you think you want your business or your invention to go. Because, even if you pursue a patent, you will have to have it manufactured. So did you patent something that has to be modified for the manufacturing process, and now your patent doesn't cover it? So always think 2 steps ahead. And as you work with other people on your journey towards starting your business, be they attorneys, consultants, folks with the SBDC, one of the best things you can do is always ask them, what are my next steps? Where do I go next? And that will help you anticipate what you need to do to be prepared for whatever that next step is, be it manufacturing, marketing, licensing, or even just going to that patent agent or patent attorney or the patent law clinic for the very first time, so that you come prepared and you can get the most out of it that you possibly can.
Great. Thanks, Peter. And Catherine.
Yeah, I would agree with everything. Yeah, knowledge is key. As a DIY person and, previous business owner to myself, like I had to teach myself a lot of things. And, Google was my friend. So was YouTube. So like learning, just running a Google search about your trademark name, running a test search, which is like the USPTO's on like Google search, TESS. So that way you can start seeing if there's any similar marks out there. Also do a Google patent search to make sure if there's any prior art, any technology that's very similar to yours. So that way you can start seeing if there's going to be any problems in terms of like registering, seeking investors and all that. And then in terms of like, if you don't go to a clinic and you are not able to find like a free service and you try to like go on Google and seek like a quick service help, where they like easy money, like charge $100 and they'll get it registered. Again, make sure, ask them like how they plan to do their search, like what systems they're using. Again, make sure no one can give you a guarantee. So if they're already giving you like a guarantee that you're getting a patent or trademark, that's likely, I don't want to say a scam, but you kind of want to be cautious about that, be informed. And then generally know how fast the process is. Again, a lot of those companies will be telling you, we can do this in like 1 month, but realistically, that's not looking like, even for trademark side, patents tend to be a little bit longer, but trademark sides also the process is now like a couple months. So again, just being knowledgeable, do your research, do Google, searches.
Great. And all of your discussion about doing research and doing your homework has generated a question. And it's, what are some good resources for market research?
I know, Eric, I'm not familiar with what the library has to offer. Unfortunately, I'm sure you guys have a lot, but I just want to throw out that I've got, through the SBDC, we've got arrangements with IBIS World, which is a market research canned report. We've got Vertical IQ coming online. Many times I'm able to run those US-based reports for free for my clients. A lot of those street prices are $1,000 a piece, depending on what they are. I don't know if you get them also at the same kind of rate, but if you need validated market research, especially if you're going for an SBIR or investors or whatnot, we can provide some of that.
Yeah, we also have IBIS World here at ASU and a few other products such as Mergent and Mintel Research. For the most part, ASU's as well as say NAU's and U of A's databases are, because they're based upon our student populations, they can't be accessed remotely. However, anyone can use them if they are physically located on one of the campuses that has those databases. So if you were to say, go to one of the libraries at ASU, you would actually have pretty much 99% of the access that a student at ASU does to those databases. So most of our libraries are open to the public. The hours are available online, so you can always check those. But yeah, if you are interested in using our resources at the universities, you can typically do that if you are physically located in one of the libraries there. So yeah, I wanted to underscore that IBIS World is a fantastic product for doing that type of market research. And also I would even emphasize, sometimes do your own market research. Sometimes just, going say to the Inventors Association and, just getting some feedback on, hey, what do you think of this idea? What do you think of this product? Especially if you have something prototyped already. That's valuable feedback, doing that primary market research where you see yourself entering into the market versus kind of the secondary research that is the more indirect, broader picture stuff that's out there. I don't know if anybody had anything else to add on that.
Eric is absolutely right. You can do a lot of primary market research on your own. You can ask people who face the problem you're trying to solve questions. You can ask them questions that don't necessarily disclose what exactly it is you're inventing. Corey, one of our hosts at the State Library, has posted in the chat a reference to the database Data Axle that is available statewide for free. And that can be a good source as well. When you do your market research, you want to ask yourself, is there a customer base for it? What does your competition look like? Is your competition making money? Because not only can Data Axle give you information on the consumer end of how many people with a certain income have certain characteristics, it can also give you information about the revenue and the size of businesses that exist in industries. So if there are only 2 other businesses doing what you're doing and they're not making much money, it might be a hint that it may not, for whatever reason, be a lucrative field to pursue.
Just to amplify Peter's point on competition, and from a business perspective, competition actually validates the space. So whenever anybody ever walks in with a business plan that says there's no competition, right, all kinds of red flags go up because one, they probably haven't done their homework. That's most of the time. And 2, if there's truly no competition, there's probably not a lot of money to be made in that space.
That's a great point. Great point. All right, I do not see any further questions coming in, and we've got just a few minutes left in our time. So I do want to thank you all very much for coming. Lou Farina from the Maricopa SBDC, Peter Grant from the Inventors Association, and Catherine Costella from the Lisa Foundation Patent Clinic at ASU. Thank you so much for your time. Thank you so much for your insight. It was incredibly valuable. And then just a final reminder to everybody attending, all the slides from today that were presented at earlier sessions, they will be emailed to you at the end of today. I am putting a link into the chat right now. If you could please complete that survey, it helps us make for a better program in the future. And there's also an email there for the PTRC with any questions that you may have about this. So yeah, if there's anything you need, any additional assistance, absolutely reach out to the PTRC through that email, and you'll get a prompt response to that. So once again, thank you to the panelists, thank you to the attendees. Whether you've joined us for all of the day or part of the day, we've really enjoyed putting this program on and glad you could all attend and contribute. And thank you very much.
Thank you.
Thank you for having us.
Thank you.